Hi, everyone. I'm going to talk about an interesting case today. I'm staying with the probate and estate planning theme and talking about this one. Uh, Factually, this case started out as a squabble. It was written up in the Indiana Lawyer, referring to it as a squabble in a family. The squabble is over a mere $8 million that a wife slash mother disinherited her stepson out of that $8 million against the father's wishes. And so once that happened and once that came to light, she was kind of caught. She says, oh goodness, I want to keep the family harmony. I want to restore everything. I'll put all the money back so that he receives his inheritance. And I just want to keep the peace. And so she did the right thing and started to put the money back. So she puts $1.5 million. And then she started thinking, maybe not. I don't think I will put the rest of that money back in. So we get this giant family feud, of course, over millions and millions and millions of dollars. And that's the factual background behind the whole thing. So I find it always interesting to see how these things play out. And estate matters can be very contentious. There's always money involved. This is quite a bit of money, of course. The legal issue in the case that I'm going to describe for you is something called the Dead Man Statute. The Dead Man Statute applies to like probate cases when you're administering an estate, and it basically says nobody can testify about what the dead person would have said or what they might have said at any given moment. And the reason for that is basically it's a hearsay rule. So you can testify about anything that you want to say, but you can't testify about what somebody else said generally. They have to come to court and give their own testimony. Okay. So obviously, when a person has deceased and they are dead, they cannot come to court and give their version of the testimony. So it's unreliable to give testimony for me to say what my deceased relative would have said. That's unreliable. And we have the written will, we have the written trust, whatever. We've got these written documents so that we don't have to have a battle over he said, she said, literally, in this case, the stepmom and the stepson. It's not a battle over that. We have the real documents, right? So while dad was lucid, before he became dementia and Alzheimer's, and his wife retitled all that money to her, he had written a trust, a very common document, a revocable living trust that said, here's what happens to my estate when I pass away. This is for my wife. This is for my other heirs, including the stepson. And it was very detailed. So at issue in front of the Court of Appeals was, does the Dead Man Statute apply to a trust? Okay, so a lot of you have written trusts. We do that all the time. And the statute really is about probate estates for like wills. And in this case, the trial court said, you know what? I really think the Dead Man Statute applies here because the decedent used the trust as if it was his entire estate planning vehicle. And so I'm going to apply it. And that went up on appeal. And sure enough, the Court of Appeal said, you know what? We agree with that argument. We agree with that line of reasoning from the trial court. We think that the will or the trust, I'm going to say that, is at issue, is so central to the deceased overall estate plan that it is akin to the estate itself. So the Dead Man Statute applies. Mom, wife doesn't get to testify about what her husband would have said, and nobody else can testify to it either. And so there's been now an expansion of the Dead Man Statute from probate cases over to trust cases, at least in some scenarios. And the interesting part of this was that the Court of Appeals looked back, and as you know, you got the books behind me, right? We look at precedent, and if you've been watching the Amy Coney Barrett Supreme Court nomination questioning in front of the Senate, you might have heard some things about stare decisis and the importance of precedent and whatnot. So we always look at, lawyers and courts and judges look at precedent to decide what do we do today. And this case goes back 130 years. I'm not going to find the case in my notes quick enough, I don't think. Yeah, 1891, the Reddick case, 1891, established these principles. And so the court said that's good law still, hasn't been overruled, hasn't been modified, and it applies in this case. And we're going to apply it here and say the trust is akin to the estate, therefore the dead man statute applies, therefore you cannot testify about what your deceased husband would have said. Now, that's the final ruling on the case, and maybe it's going to go up to the Supreme Court and they'll get another chance to take a bite at the apple. But it points out a few important facts. And I think that the husband, the decedent, got Alzheimer's and dementia later in life was perhaps important because you might start getting opinions about what he said when he was no longer lucid. And you would then have a giant argument about testifying about what he said with his respect to his affairs and disposing of his estate. When he was 100% lucid, then he started to lose it a little bit, and then he became more and more Alzheimer's and dementia and became totally incompetent. Right. So where do you pass that line there? And so it's very important, maybe as a fact there, peeking behind the curtain a little bit. It also brings up the very key fact that we write things down, like in real estate contracts. There's something called the Statute of Frauds. The real estate contracts are important documents and important agreements. And in order to make certain that there's not fraud and there's not a misrepresentation or a misunderstanding, to clarify things, we always write down real estate contracts. And so since the olden days in Old England, we have the Statute of Frauds requirement. So we write things down that are so important. Similarly, in an estate with your will and your trust, we write those things down. We don't just verbally say, hey, on my deathbed, this is what I want to do, because it's so unreliable what would have been said and who the witnesses were and undue influence and that kind of thing. So we write those down just like the real estate contracts. So those are two really key factors in this thing. Keep your eyes open. We'd love to help you with your estate plan if you'd like. We do it quite a bit, and we now know that your plan is going to override what people might say they heard you talk about after the fact. So Dead Man's statute applies under your will and also under a trust agreement that you wrote up. Stay tuned. Thanks a lot.